All right, welcome to company law discussion all about shareholders remedies. The remedies usually been sought by shareholders when there will be abuse of powers or unjust or unfair practices within the company. The following are actions or remedies based on underlying law. So we have three: personal action, representative action, and derivative action. For personal action, a shareholder can file a case and go against the company or the board of directors if her or his personal rights had been interfered. So what it means is that the shareholders have specifically empowered to have voting rights or rights to receive dividends or rights to receive distribution from the company. If these rights had been interfered with, okay, by the company or the directors, then the shareholders can file for personal action. Representative action is a collective personal action where one of the members can sue on behalf of all others. Of course, they must have suffered the same wrong. Derivative action, an individual shareholder sues on behalf of the company because wrongdoers are in control of the company. So in this case, an individual had been unjustly treated and he cannot defeat the majority shareholders because they are in control. So what he can do is he can sue on behalf of the company. So which means is the focus will be on the company's benefit or the best interest. The case law that we can refer to here is Foss versus Harbottle. The company and not the shareholder is the plaintiff. So why do we need remedies? As previously mentioned, there will be chances that directors and even majority shareholders do harm to minority shareholders. So what the minority shareholders can do if they are being disadvantaged is to file for derivative action or at times they can sell their shares. But selling up shares may not be always be possible because there might be some provisions on the constitutions of the company which they are not allowed to sell the shares right away, especially for medium size and small companies where there is no active market for the shares. So meaning it's really quite difficult to sell the shares right away. With regards to that, the law had provided a provision for remedies. So these are the statutory remedies. First will be oppression remedy. Second is putting the company into liquidation because it is just and equitable to do so. And granting an injunction to prevent a contravention of a Companies Act 1997 or Companies Constitution. When it comes to oppression remedy, if the court finds that the company's affairs acted or likely to be acted will be oppressive to or unfairly discriminatory against or unfairly prejudicial to a shareholder, then this will be the remedy that the shareholder can apply for. So examples of abusive actions that the shareholders might be affected will be abusive exercise or power by the director's failure to act for the best interest of the company. Now, the shareholder will be able or can apply for liquidation even if it is still able to pay debts. Commonly, the reason why the company is going into liquidation is their inability to pay debts. But there will be what we call voluntary liquidation, which can be filed or requested by the shareholder. Of course, there will be grounds for them to apply for that voluntary liquidation. An example of this, if the company no longer serves the purpose, then we can or the shareholder can always ask for voluntary liquidation. So here stated where a shareholder can apply to have the company put into liquidation. The first one is it is just and equitable to do so. Like for example, if the company is performing fraudulent acts or even doesn't have the purpose anymore, then they can put the company into liquidation. The second one that mentioned here is the company or board has persistently or seriously failed to comply with Companies Act. And the third one is the company does not comply with essential requirements of the company. The essential requirements of the company can be seen in Section 10 and Section 11 if you go further in the Companies Act. So these are the essential requirements. Company shall have a name and one or more shares and one or more shareholders, having limited or unlimited liability for the obligations of the company, and one or more directors. So if the company doesn't comply with the essential requirements, just one of these, then the company can be put into liquidation. Statutory injunction is where the court requiring a person to do something. We call it mandatory injunction or injunction to restrain action. Section 142 of Companies Act empowers national court to grant both type of injunction. Okay, the first one is restraining a person who is engaging, proposes to engage in conduct that is or would contravene the Constitution of the company or the Companies Act 1997 from engaging in that conduct, or requiring to refuse or fail to do an act or thing that he is required to do by the Constitution, of course, of the company or the Companies Act 1997 to do that act or thing. So those are the shareholders' remedies in cases of abuse, unfair treatment, and loss of purpose of the company. So these are actions that they can always do so if they feel as a shareholder they are being oppressed. That's it for our discussion. Thank you for your time.